I hired a remote employee abroad but managed them from Dubai. Could UAE labor law still apply to me as the employer? Well, it depends. And the answer usually turns on sort of structure, classification, and documentation of you as the employer and also your relationship with this so-called employee. So some of these key questions to kind of consider, are you operating as a UAE legal entity or as an individual in the UAE? And is the person engaged as an employee or an independent contractor or a service provider or a freelancer? And then is there a formal agreement between you, the company, or the individual and the employee, and where is it registered? So, for example, if you are a UAE entity and established in the UAE and you registered, you hired this employee abroad, but you've documented the employee as your employee through the economic zone where that licenses you as a company. So then it's called a sort of registering your employment agreement with the authority. Then in effect, that employee becomes officially your employee of the company. So even though they're not based in the UAE, you don't necessarily need to register them with the authority. But now you've taken that employment relationship and you've formalized it by virtue of registering a formal employment agreement with the authority where you're based. And those who are who work or have companies in the UAE would know that there's different economic zones where a company can be set up. So if you're in the mainland, it is possible to register your employment agreement with the mainland authority. If you're in a free zone, you would register the employment agreement with the free zone authority. Sometimes companies do that. So if this is your scenario, so that even though that employee is based in the UAE and maybe even paying them outside of the UAE. Because you formalized your employment agreement within the UAE with the governing authority, so that can actually give rise and will give rise to an employment relationship, and therefore, in this case, the employee will, on the basis of this agreement, have the right to request the usual entitlements that employee would otherwise be expected to receive under the labor law. So that's kind of one extreme example, but it does happen, and that's why I'm using it here. And so, but in other cases, if you are company based here, it's sort of same scenario, and you have the same employee, but you do not formalize your relationship by virtue of registering with the economic authority, but rather you just have a private agreement between the two of you. Then that, because the employee is based elsewhere, that does not give rise to an employment relationship per se. It could be a freelance, it could be a contractor relationship, but not an employee relationship. And in most cases, in most jurisdictions, the employment law applies of the jurisdiction where the employee is based. So if this employee is based abroad, by default, they will be subject to the jurisdictions, the employment laws of the country where they're based. So therefore, just even the existence of a private agreement between the two of you will not give them the rise to claim employment benefits in the UAE per se. So really much depends on how you structure your employment relationship. So if you just want to be safe, there's always an option of drafting obviously a private agreement. You should always have an agreement, and then clearly in this agreement document what sort of an employee this is. It could be a part-time employee, it could be just a freelancer, it could be just a contract, like a service provider, and this is just a contract for you to hire their services. So the employment relationship, in other words, can be described and classified in many different ways. So depending on what your circumstances are, the relationship may or may not be deemed as an employment relationship, and therefore entitling the employee to the otherwise sort of the regular employment benefits under the UAE law.